Mrs. Sherman?
No, not that I would, besides work, no, I don't remember.
Was there a time during that time frame when you were speaking with Mrs. Sherman and she was sharing with you a recording that she had received?
I don't recall that. I don't recall her saying anything to me.
Did you listen to a recording?
I listened to a recording.
And tell the court the circumstances of you listening to it.
I don't recall.
It's possible.
I don't recall.
Because it's been so long.
I don't recall because I heard the message. Somebody played it for me because it was on the recorder.
And the circumstances around that, you just don't recall it because it's been so long?
I don't recall who I work with to know who played the message for me. For lots of people.
It was a long message?
Did the voicemail identify Elisa by name?
No.
Okay. And do you know if Elisa recorded that voicemail?
Not that I know of.
So the voicemail you're talking about, and with the defense counsel, right?
Right.
Was something left on kind of a general number that...
Welcome back to another courtroom breakdown where every detail matters, and sometimes the smallest piece of evidence can completely change the direction of a case. Today's testimony focuses on a chilling voicemail, a witness who received and reported it, and the unanswered questions surrounding a message that appeared shortly before the tragic death of Elisa Sherman. The witness you're about to hear from, Mary Alice Rigdon, worked alongside Elisa Sherman at the Cleveland Clinic for years. Her testimony takes us inside the workplace environment, where a threatening message was allegedly received and later connected to the investigation. But as you'll see, courtroom testimony is rarely simple. Memories fade, reports are challenged, and every single word is examined by both sides. The prosecution focuses on the importance of this voicemail, the threatening language, the timing, and why it raised concerns before the homicide. Meanwhile, the defense begins pulling apart the details, questioning who had access to the phone, whether the message specifically targeted Elisa, and how reliable the recollections are after more than a decade. Was this voicemail a warning sign that should have been investigated further? Was it a critical clue missed during the investigation? Or does the evidence raise more questions than answers? Stay with us as we break down the testimony, the courtroom strategy, and the key moments that could influence how this case is understood.
Could you state your name for the record, please?
Mary Alice Rigdon.
And how are you connected to this case?
I worked with Elisa at the Cleveland Clinic Infertility.
And for how many years did you work with?
We started in 2003 and until she passed away. 2013.
If she passed on March 24th, 2013, approximately a week or so, maybe a little less than that, did you have an opportunity to meet with her?
I don't know the exact days I worked. Our schedule was different every day, so I can't, unless I had the schedule, I couldn't tell you what days I worked with her. She worked every day, I worked part-time.
Early in that week, is it fair to say, on the week prior to the homicide, did you have a conversation with Mrs. Sherman?
No, not that I would, besides work, no, I don't remember.
Was there a time during that time frame when you were speaking with Mrs. Sherman and she was sharing with you a recording that she had received?
I don't recall that. I don't recall her saying anything to me.
Did you listen to a recording?
I listened to a recording.
And tell the court the circumstances of you listening to the recording.
When I came back into work, I was told that we got a message on the back phone, which is like a private number, that was kind of scary, and then I listened to it. And
as a result of that, did you call the police?
yes, yes.
And when you spoke to the police, did you tell them that there's a voice message that was received approximately a week prior to Elisa's death.
Yes.
And did you tell them that the message was received on a phone number 216-839-3176?
Yes.
And to the best of your recollection, the message that was received on that phone number, what was said?
This is the
part that
moment where the courtroom testimony becomes significantly more serious. The witness recalls hearing a threatening voicemail with the words, "Don't think you can hide. We'll find you." Those words immediately stand out because they suggest intimidation and a possible personal conflict. However, in a courtroom, a statement like this is only one piece of a much larger puzzle. The important questions become, who made the call? Who was the intended target? When exactly was it received? And was there enough information at the time to identify a suspect or prevent what later happened? The witness clearly remembers the threatening tone, but also admits that many details have faded over time. That creates a major issue both sides will focus on: the difference between remembering the emotional impact of an event and remembering the exact facts surrounding it. What do you think? If you received a message like this before a serious crime occurred, would you consider it a major warning sign? Or would the lack of a direct name or identification make it harder to act?
The part that I remember was they said, "Don't think you can hide, we'll find you."
And describe the tone of the voice. Was it menacing?
Yes.
As a result of that call and what you heard, did you call the police and ask them to investigate?
I called them, yes, I called them to tell them about the phone call.
And to your knowledge, did anyone follow up with you as relates to that?
No, nobody followed up with me.
And to your knowledge, was that phone call, that message, ever recovered from the Cleveland Clinic?
Not that I'm aware of.
And that week prior to the homicide, did you have conversations with Elisa about that message?
I don't recall.
It's possible,
I don't recall.
because it's been so long.
I don't recall because I heard the message. Somebody played it for me because it was on the recorder.
And the circumstances around that, you just don't recall it because it's been so long?
I don't recall who I work with to know who played the message for me.
And it was a long message or a short message?
It was what I said, like, "We're going to find you, don't think you can hide." I don't recall what happened. It was a short message. It wasn't long.
But those are the words that you remember?
Those are the words I remember.
Okay. The police didn't reach out to you to try to do anything? Did you do anything to double back on them?
No.
Or did you feel that you had done your job?
I felt
as a
that
citizen?
I assisted in what I could do because yes.
Thank you very much.
You're welcome.
Yes, thank you. Mrs. Rickman?
Yes.
My name is Kevin Filiatro. I'm an assistant prosecutor. Nice to meet you.
Nice to meet you.
You said that this was left on the back phone?
The back phone, yes.
Describe where that is in the office and who has access to that phone.
Our staff has access to it. The doctors had access to it. And my daughter had access to it. And some family members, I believe, had access to it. I don't recall.
Now we see the defense strategy becoming much clearer. The defense is not necessarily arguing that the voicemail did not exist. Instead, they are attacking the connection between the voicemail and Elisa Sherman specifically. The key issue here is access. The witness explains that this was not a personal phone belonging only to Elisa. It was a workplace phone connected to a surgical center office environment, with multiple people having access. The defense highlights this because a threatening message on a shared line creates additional uncertainty. Legally, this matters because evidence must be connected to the person or event in question. A threatening message can be important, but investigators still need to establish who it was directed toward and who may have sent it. This is a classic courtroom battle. The prosecution looks at the timing and threatening nature of the message, while the defense focuses on gaps, unanswered questions, and alternative possibilities. Do you think the voicemail becomes stronger evidence because of when it happened, or weaker because the phone was accessible to multiple
I don't
people?
recall.
Sure. So is it fair to say this phone was not exclusively used by Eliza Sherman?
Can you repeat that?
Here, let me ask you this. Was this just Eliza's phone, or was it everyone's phone?
It was the back office. It was the surgical center's office.
Okay.
Setting.
All right. So was that Eliza's own office, or was it for lots of people?
It was for lots of people.
Okay. Did the voicemail identify Eliza by name?
No.
Okay. And do you know if Eliza recorded that voicemail?
Not that I know of.
So the voicemail you're talking about, and with the defense counsel, right?
Right.
Was something left on kind of a general number that lots of people could use?
No.
No? Tell me.
Not a lot of people, no. It was a private number. It didn't roll over to that number. It was just used by certain people.
Okay. And how many people would you say? If you could put a number on it.
I have no idea. I don't know.
Okay. Well, one or more than one?
More than one.
Okay. More than 10 people?
Yes.
More than 20 people?
Yes.
All right. And is this the type of number that would have been on someone's business card?
No.
Okay. And so when you told police or told somebody that this was probably a call from an internal number?
I didn't say where it was from.
Okay. All right. Okay. So it was a voicemail left on a phone that over 20 people could use,
Yes.
right? And the voicemail did not identify Eliza by name.
No.
One moment, Judge. And did you ever speak to a police officer about this?
No.
No? Well, here, the defense has something on this screen over here, which looks like a police report, and it looks like your name there.
Yes, I've seen that.
Okay. So this is a police report with your name on it, right?
Yes.
Did you speak to police, maybe the officer who wrote this up?
I don't recall.
Don't recall, okay. Is it possible you did?
I don't recall. I talked to the person that answered the phone.
Okay. Nothing further, Judge.
Thank you. That's it.
I'm just going to read.
This section highlights one of the biggest challenges in older criminal cases: memory versus documentation. The witness is shown a police report from years earlier, and several statements are read back to her. But instead of confirming every detail, she repeatedly says she does not remember making those statements. This does not automatically mean the report is inaccurate. Courts understand that witnesses may struggle to recall specific conversations many years later. However, credibility becomes a major issue. Attorneys often use prior statements to test whether a witness's current testimony matches what was recorded closer to the time of the event. The prosecution appears focused on refreshing her memory and showing what information was previously provided. The defense, meanwhile, has already emphasized uncertainty surrounding the voicemail details. This is where courtroom battles often happen, not just over what happened, but over how confidently someone can say they remember it. When a witness says, "I don't recall," repeatedly, do you see that as understandable after so many years? Or does it create doubt about the reliability of the testimony?
I'm just going to read part of the report, and if you recall, if this refreshes your recollection, great. If it doesn't, that's fine. It says, Rigdon stated she didn't think anything of it, but the victim was concerned and recorded the message on her cell phone. Do you recall making that statement?
No,
And do you recall that happening or not happening?
I don't recall that happening.
Rigdon stated she was aware the victim was going through a contentious divorce, but the victim stated that the caller was not her husband. Do you recall making that statement?
No, I don't.
Rigdon stated after the victim's death, the Cleveland Clinic police responded to the victim's office. Rigdon stated when she found out how she was killed, she made the police aware of the voicemail message. And Rigdon stated that the
Here
thing
we
that stuck
reach
out-
another important turning point. The testimony introduces a possible connection between the voicemail and a Cleveland Clinic phone number. The report being read in court suggests additional details were previously provided, including information about where the call may have originated. But once again, the witness cannot independently confirm those details today. This creates a complicated situation for the jury. They must consider both the written record and the witness's present-day memory. In criminal trials, evidence is rarely perfect. Investigators often build a timeline using multiple sources: witness statements, documents, phone records, and physical evidence. The strength of a case comes from how those pieces fit together. The question here is whether this voicemail represents a meaningful clue connected to the crime, or whether the uncertainty surrounding the details leaves too many unanswered questions. As this testimony wraps up, the focus shifts toward what can actually be proven in court versus what remains speculation. And that difference is one of the most important principles in any criminal
Rigdon
trial.
stated that the thing that stuck out in her mind about the call was that it originated from a Cleveland Clinic phone number of 216-839-3148. Do you recall that information, knowing it, and then, well, do you recall that information?
No, I don't. No, I don't.
You don't deny that you may have said it, you just don't recall it.
I don't recall it.
And it says that you're unaware of what Cleveland Clinic did with the information. So obviously, this was 13 years ago, maybe even more at this point, correct?
Yes,
And you're not disputing that that's what it says, you just don't recall it.
I don't recall it.
All right, thank you.
Thank you. Counsel,
Nothing based on that.
you may step down. You're free to step down.
And Ms. Rigdon's free to leave.
This testimony provided the court with an important look at the events surrounding a threatening voicemail allegedly received before the death of Elisa Sherman. Mary Alice Rigdon testified that she heard a disturbing message, reported it, and remembered the threatening nature of the words. However, years later, several details became unclear, including exactly who had access to the phone, who the message was intended for, and certain statements documented in the police report. From the prosecution's perspective, the voicemail could represent a significant warning sign that deserves attention. From the defense perspective, the uncertainty surrounding the message creates questions about its connection to the crime. Ultimately, this testimony shows why courtroom trials are about more than just dramatic moments. They are about evidence, reliability, and whether facts can be proven beyond a reasonable doubt. Every detail, every statement, and every contradiction can influence how a jury views the case. What do you think about this testimony? Was the voicemail a crucial piece of evidence? Or were there too many unanswered questions? Let us know your thoughts in the comments. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.